came back with the guilty verdict and the life sentence, I was stunned. It literally knocked the wind out of me. My knees buckled, my butt hit the chair, and had that chair not been there, I'd have hit the floor.
There wasn't really a lot of deliberation. We all felt so strongly that this was justice for Christine and that we were doing the right thing.
When I went to prison, a lot of stuff is immediate. I mean, you can't plan for the future. It's in your face.
There is a lot of evil residing within these walls. I've sat in the day room and I've had men say, I'm innocent, I'm innocent. But with Mike, it was different. When he spoke to me, I'm innocent, I just believed him.
I remember from my childhood receiving letters from my father. I didn't have memories of him outside of the visits to prison. It was like receiving letters from somebody that didn't exist.
With all the bad things that had happened, my wife's murder, my arrest and conviction, my life sentence, the failed appeals, the DNA snafus, all of that didn't do me in. But when I lost him, that's what broke me.
There is an offense report from 11 days after Chris Morton was murdered. And it's a transcript of a conversation about what Eric saw. Coming from Chris's mother, talking about Eric, talking about a monster with red hands, and that person is clearly not Michael Morton, is devastating to the state's case. And they sat on this information for 25 years.
Michael Morton was wed to Christine Morton and soon after had a son named Eric. On August 13, 1986, Christine Morton was murdered in their home in Austin, Texas. The murder trial begins on February 9, 1987, with Michael Morton as the defendant and suspect to the murder. Prior to the trial and just days after the murder, family and friends offer statements of suspicious activity pointing to another possible suspect to the police. Family members find evidence with possible DNA implications near the crime scene and again were turned over to police. Eric, at age 3, gives a statement and deposition stating that he saw a monster with red hands and a big mustache hurt his mother. Eric specifically states that his father was not at home and was not the monster. Judge William Lott orders the district attorney to provide his case files for inspection. The statements from the neighbors and the statements from Eric are not included. Michael Morton is subsequently found guilty and sentenced to life in prison in 1987. Morton's lawyers request a new trial because of the Williamson County District Attorney mentioning an inch-thick stack of police reports that they, the defense, never saw. The motion is denied. In 2002, the same Williamson County District Attorney becomes a state district judge. In 2005, under Texas's post-conviction DNA laws, Morton requests testing on several items from the crime scene to include a bloody bandana found near the crime scene and fingernail scrapings from Christine. The request was made to have the DNA compared with a murder that occurred near Morton's home. The testing is granted on the fingernail scrapings, but denied on the bandana. The DNA test is inconclusive, and the court cannot exclude Morton as the murderer. In 2008, Texas Attorney General orders all investigative documents regarding the Morton murder released to Michael Morton's lawyers. Eric's statement is found along with police reports detailing Christine Morton's credit card and check being used fraudulently after the murder and a witness statements made by the neighbors. In 2010, the bandana is tested for DNA per the request of the Third Court of Appeals. In 2011, the bandana is found to have evidence from Christine Morton and another male who is not Michael Morton. The DNA is uploaded to a national database, at which time a hit is made to Mark Allen Norwood, who was arrested in California in 2007. It is learned that the DNA matches that of a hair found at another murder scene in which the new suspect, Norwood, lived less than a mile away from. Morton's lawyers learned of the connection between the other murder and Christine, along with receiving all of the missing information withheld by the Williamson County District Attorney's Office. A hearing is held in October requesting the release of Michael Morton per the new DNA evidence and withheld documents. Almost 25 years after the brutal murder of his wife Christine, Michael Morton is released from prison on October 4, 2011. The former district attorney gives testimony about his role in the Morton prosecution. Murderer Mark Norwood is arrested in Bastrop, Texas for the murder of Christine and suspected 1988 murder of another female. In 2013, the Michael Morton Act is signed by Governor Rick Perry. Therein lies the dilemma. Because of the existing law, Brady v. Maryland, only certain types of information are required to be disclosed to the defense. After the Michael Morton Act was passed and signed, the information and evidence required to be handed over to the defense has been expanded. For law enforcement, this means that your case file will be more scrutinized. Not only should you include all material relative to your case, but you are required to do so. Failure to document all aspects of the case and failure to give this information to the District Attorney's Office could have devastating effects on your case. Here's a brief synopsis and purpose for each of these bills. The purpose of Senate Bill 1611, otherwise known as the Michael Morton Act, requires prosecutors to give attorneys representing the accused any evidence that is relevant to the defense's case. That evidence must include all documents, notes, statements which can be written or electronically recorded. The intent of the bill is to ensure that the key facts that could affect the trial aren't hidden. Similar laws such as the U.S. Supreme Court's decision in Brady v. Maryland in 1963 already requires prosecutors to hand over to defendants any exculpatory evidence that is material either to guilt or to punishment. Exculpatory evidence is evidence such as statements tending to excuse, justify, or absolve the alleged fault or guilt of the defendant. The Texas Senate bill goes into more depth to list items to be disclosed, regardless of whether the evidence is material to guilt or punishment. The evidence has been expanded from exculpatory to include impeachment, mitigating documents, items of information that tend to negate guilt of the defendant or would tend to reduce the punishment for the offense charged. The words document, item, or information could mean numerous things. Offense reports or notes taken regarding an offense report, designated documents or papers, written or recorded statements of the defendant or witness, including witness statements of the law enforcement officers, or any designated books, accounts, letters, photographs, or objects, or other tangible things not otherwise privileged that constitute or contain evidence material to any matter involved in the case. What is discovery? Discovery in the law of the United States is the pre-trial phase in a suit in which each party can obtain evidence from the opposing party by means of discovery devices, including requests for production of documents, requests for admissions and depositions, or any evidence pertaining to a case. How does this affect law enforcement? Discovery is found in the Code of Criminal Procedure, Article 39.14, Subtitle A, titled Discovery. The pertinent portion of this article in subsection A went into effect January 1, 2014. It reads, "As soon as practical after receiving a timely request from the defendant, the state shall produce and permit the inspection and the electronic duplication, copying, and photographing by or on behalf of the defendant of any offense reports, any designated documents, papers, written or recorded statements of the defendant or a witness, including witness statements of law enforcement officers, but not including the work product of counsel for the state in the case and their investigators, and their notes or reports, or any designated books, accounts, letters, photographs, or objects, or other tangible things not otherwise privileged that constitute or contain evidence material to any matter involved in the action and that are in the possession, custody, or control of the state or any person under contract with the state." As a law enforcement officer, it means you are responsible for turning over all information relating to the case you submit. The article clearly states that you shall produce any offense reports, designated documents, papers, written or recorded statements of the defendant or witness, to include those made by law enforcement officers that may constitute or contain evidence material to any matter involved. To keep it simple, if you as an officer have something pertaining to the case, the district attorney's office or prosecuting attorney has to have it. What constitutes an offense report? Designated documents and papers. An offense report is self-explanatory. Any generated report in which an offense is investigated and a complaint is filed. Designated documents are any supportive documents attached to an offense report that support the original document, whether it be supplement reports, attached crime scene logs, evidence sheets, and so on. The gray area and most arguable item listed is the simple word papers. For an officer investigating or documenting an incident or offense, it can mean any piece of paper that you write on that has any information pertaining to an investigation, incident, or offense for which you are dealing with. Field notes is the big ticket item. If you keep field notes on any form of tablet, notebook, diary, or scratch pad, that information can be considered evidence. The debate could stem from a defense attorney asking how you document your way through the investigation, and you indicate field notes, or another officer stated that you merely mentioned your field notes. Those notes can be requested for evaluation for evidentiary value. The safest method for handling your field notes is to make a copy of them and include them with the case file, making sure the district attorney's office receives a copy. If you inadvertently put information about another case on the field notes due to handling multiple reports for the day, just make separate copies and place a copy in each case file. The information can be sorted out between you and the prosecutor when you review your case. Witness statements. It is understood that all witness statements must be turned in with the original report. It's also important to remember that all witness statements must be submitted. Make sure that you copy the front and back side if there is one. When on a scene have you ever passed out a witness statement, got one back with no pertinent information, and discarded it or did not include it in the report? If a defense attorney hires an investigator who learns that a statement was given to a person on scene and recovered by officers but not included in the report, how well do you think that will go over with the judge when they ask for it? What if you are viewed on your Coban taking an oral statement which you failed to burn a CD to and deliver to the district attorney's office? How will the district attorney's office treat you when they realize that the case is now doomed because of an accident or, even worse, negligence? The Coban constitutes a photographic image of what occurred on scene as well as testimony. What about using a cell phone at a scene to relay information to a supervisor by text or picture? Personal cell phones, in of themselves, are not discoverable. The statute basically states that if you use your personal cell phone to text a detective, supervisor, or another officer about the case itself, and it is material, a copy of the text needs to be in the case file. This can be done either by making a photographic copy of the text, a digital download, or whatever it needs to be to include that in the case file. If you take a photograph or video of a crime scene or investigation, the images have to be made part of the file. Remember, any media relating to a crime cannot be distributed to the public, especially the media by an officer. Because you took an image or video does not mean that you have to turn over the entire cell phone. The information, whether it is a text, video, or image pertaining to the case, does have to be submitted with the case file. A worst case scenario could be that a defense attorney would ask to have your cell phone turned over for examination to make sure that all information pertaining to the case was collected. The defense would have to articulate how they believe evidence or information is contained inside your cell phone, and then, according to the district attorney's office, they would attempt to limit the depth of the search into your phone and limit the search for information relevant to the case only, and all other information be excluded. What about multiple subjects on scene? If you identified subjects or possible witnesses by writing their information on a notepad but did not include them in the report, should you consider submitting the paper with the names and dates of birth in the case file? Absolutely. These are potential witnesses you have identified. If you choose not to include them in the report, but made contact with them, the defense could argue that you withheld potential witness information that could be relevant or material to their case. If you include the scratch pad notes with the information, then the defense could determine for themselves the importance of each person on scene and if their testimony is relevant to their case. Even if the names are put into the report, it would be perilous not to include the field notes because it clears up the potential of the defense asking if there could be a discrepancy between your field notes and the offense report during a cross-examination. It reinforces your documentation, making it less questionable by defense or the DA's office. What about a supervisor's field notes generated to send out a supervisor's email for information purposes? These notes are just as important as the notes created by the reporting officer. If it pertains to the case, the supervisor should submit his or her notes along with any correspondence in the case file. the statute specifically mentions any material or written statements, including those of law enforcement officers. Some of the information obtained by a supervisor may be received verbally from an officer and put into the supervisor's notes, but fails to get into the officer's offense report, making the supervisor's notes evidentiary. Could you be filed on for tampering with a government document or tampering with physical evidence if you destroy or have destroyed your field notes? According to the District Attorney's Office, it is arguable that the field notes you destroy could be considered a document or thing listed in the statute. It is arguable that the court could ask you to provide the shredded material. It is also arguable that the defense could accuse you of tampering with or destroying the physical evidence. You have to be aware of the different scenarios in which your actions could be questioned. There is no definite answer because it is all subject to argument in court.